going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Got a good one. Technically, I've got two. Same defendant, two different hearings, 2 days apart, or 1 day apart. Yeah, anyways, what happened yesterday, what happened today? Words. All right, so first hearing, defendant comes in with attitude, judge isn't happy about it, and yeah, you'll see. You'll see what happens, but yep, no buts. Let's just play the video. When before I hit that play button, you know what to do. Hit the like and subscribe. Do your junk backflips. Let's go.
In State of Michigan versus Johnny Buckner Jr. 2500242 FY.
Oh, Jeffrey available on behalf of the people. Sorry.
Good morning, Your Honor. Melanie Elbiwanji for Mr. Buckner, who's up here Zoom.
And you are Johnny Buckner Jr. on the video?
Here we go.
Yes.
You. Today is a date for probable cause conference. We have a preliminary exam set for next week. I also have here a bench warrant that I've issued for arrest of Mr. Buckner. This bench warrant is pertaining to a violation of the no contact order. So I'm going to arraign Mr. Buckner on that at this time. Mr. Buckner, it is alleged that you violated an order put in place by the court on January 28 of 2025, wherein you were ordered to have no contact with Ms. Deshea Reed. You're not to be within 2,000 feet of where she lives, works, or goes to school. The only exception in here appears to be that you are allowed to pass within the zone briefly on your way to and from work. It is alleged that on or about January 30, 2025, that you violated the no contact order via telephone calls and text messages. If
That's not me.
That is true. The bond you are out on could be revoked. You could be in contempt of court, for which you could be sentenced up to 93 days in jail and or $7,500 in fines consecutive to that which you already face. You should understand that you have the right to have an attorney in this matter, and Ms. Wanji is already representing you in this case. You have the right to a trial by a judge, not by a jury, but it would have to be proven beyond a reasonable doubt that you did in fact violate a court order. Ms. Wanji, are you asking that this be set for a hearing?
Yes, Your Honor, thank you.
All right. Are we going to leave the exam as scheduled for the 13th?
Yes, Your Honor.
Okay, so we'll set this for the same time. Feb 13, 8:30.
It's not real long.
Where is it?
Ms. Wanji, as for bond on this bench warrant here.
Your Honor, I would ask the court to set a PR bond. This case, I think that my client will be able to show that he did not violate the bond conditions, and I think it will also be detrimental for him to be in jail when he has to prepare for this matter. The preliminary exam is next week, and he also has a job. He already lost one job because he was in jail last time. Otherwise, you know, there is nothing in the court file saying that he has already violated the other condition besides these allegations that he violated the condition of his bond, that he has a tether on. So with the tether, it's easy to know where he was at the time that is alleged that he may have violated the condition of the.
But the violations aren't just the allegation that he went within the zone. The violations are text messages, which include, you're trying to keep me from my son. I'm going to call CPS and have them take him from you. You have until tomorrow morning to let me see my son. So all of those messages would be a potential violation of the no contact order if he did in fact send them. At this time, bond will be set at a PR bond, but if these violations are substantiated, there's a good probability Mr. Buckner is facing jail. Bond is set at $5,000 personal recognizance with all conditions at this time remaining in place, and we will have our hearing next week.
Okay, thank you, Your Honor.
As for the people, anything else that we need to address?
No, Your Honor.
Okay, Mr. Buckner, remember that you are in fact on bond. You need to be reporting to pretrial services. Have you reached out to them?
No, my phone broke. I can barely do anything. I'm using somebody else's computer.
Person, if you don't call them, you know what? I just arranged you on a bench warrant. You're telling me that you're not compliant with bond, and your attitude is that you don't intend to comply. Instead of doing what most defendants do at probable cause conference, which is say, I'll call them today. I'll go there today. I want to be compliant with my bond. You just say, I can't do anything.
I'm letting you know my phone is broke. I can't call nobody.
Then you need to
I
go
can
there.
barely.
Then you need
Go
to go
where?
there.
With what ride?
Your
What
Honor, I
ride?
will
What
talk
car do I have?
Mr.
All my
Buckner.
cars are sitting
Mr.
at the house.
Buckner,
Okay, I'm sorry. Mr. Buckner has an in-person hearing next week. His attitude is inappropriate. So I guess I'm going to revise, and I'm just gonna let the bench warrant stand and have him turn himself in on the bench warrant.
I'm not even talking rude. This is how I talk. I'm
Your
letting
Honor,
you know my phone is broken. I told my prosecutor
Mr.
this
Buckner,
yesterday.
please, Your Honor, I will have Mr. Buckner come to our office today. I will be there. He's gonna call pretrial services using our phone.
Well, you'll have to have him come by the court also to get arraigned on his bench warrant, because I'm gonna keep the bench warrant in place. His response today gives me no confidence in his following court orders. All right, that will conclude this hearing. We'll continue it when I see Mr. Buckner in person.
Thank you, Your Honor.
Thank you. You can click leave there, Mr. Buckner, and get out of the Zoom.
All right. Like I said, that happened yesterday. Now this happened this morning. Now I was trying to look. I think he might be in handcuffs. So he did actually turn himself in. Looks like it was either last night or this morning because he's still in. He's not in the jail jumpsuit, but yeah. Anyways, let's keep going.
On the record in the state of Michigan versus Johnny Buckner Jr., 2500242FY.
Jeffrey Billabell on behalf of the people.
Toby White on behalf of Mr. Buckner. He's with me at council table in person.
And you are Johnny Buckner Jr.
Yes, Sean.
All right, thank you. Today is our rescheduled date to reconsider the bench warrant arraignment. I attempted to arraign Mr. Buckner yesterday, and I had gotten so far as to setting bond when Mr. Buckner behaved in such a way that I felt like an in-person appearance was necessary to sort of convey, Mr. Buckner, this is a serious matter. And it's not something to be sort of messing around or being disrespectful about, because we need, as I often say, bond is an exercise of trust. Being on bond means I'm trusting you to do what I've asked you to do. And when you disrespect me, then I lose trust. So in order to be on bond, there has to be some trust there, because I'm basically letting you leave on a promise you're going to do everything I said. So today, what I have is a bench warrant, which was authorized, as I mentioned to you before, due to alleged no contact order violations. You were arraigned by Magistrate Milmore January 28 of 2025, and she ordered you to have no contact with, I keep forgetting how to say her name, Miss Reed, Deshea Reed. And we had allegations that 2 days later, on January 30, at 4:24 p.m., Ms. Reed had called the police and complained that she had repeated phone contacts from someone who she believed to be you. So it says there were phone calls from an unknown number. That's one thing. And then there were texts, the context of which leads her to believe that the texts were coming from you. And I read some of those into the record yesterday. The texts say things like, you're trying to keep me from my son. I'm going to call CPS to take him from you. You will have until tomorrow morning to let me see my son.
All right, this is actually interesting. First, he is wearing handcuffs. I can see him clearly now. But Second, the bond violation is these texts and phone calls from an unknown number. Even if that is him, how would they prove the? How would the state be able to prove that? Are they going to bring in, GPS triangulation experts to pinpoint him exactly? That's ah interesting.
There was one additional reference, which was sort of what your lawyer was talking about, where the message said that you had allegedly, she thought it was you, texted that you were inside her house and were asking where she was. And your lawyer at that time, Ms. Wanji, asserted that you're on a tether, so that would show that that text, if sent, either A, wasn't from you, or B, was false. But it doesn't change the fact that there's an allegation that there's all these texts, which would violate a court order. Violating the court order could result in the bond that you're out on being revoked. You could be in contempt of court for which you face up to 93 days in jail and or $7,500 in fines consecutive to that which you've already faced. You have the right to have an attorney, and it looks like Mr. White has now subbed into your case. You have the right to a trial, not by a jury, but just by a judge, but it would have to be proven beyond a reasonable doubt that you did in fact violate a court order. As I told you yesterday, our intention would be to set this for a hearing on whether or trial on whether you violate the court order at the same time as your prelim, which is currently scheduled for February 13 at 8:30. And then the next thing that happened is I asked if Mr. Buckner is reported to pretrial services, and that is when everything sort of came apart after I'd already decided to PR him on this because I believed his tether would make him safe, and we would address the texting issue at the time of the hearing. And that's where we sort of left off. So, Mr. White, you'd like to continue this for the hearing on February 13, 8:30?
I would.
Okay. And then as to bond.
I'm new on the case, as we know. It's my understanding that there will be strong evidence that he did not engage in that conduct, that it is fraudulent. And he is on tether. He is here, he is contrite, he realizes he lost it. And that was all on him. He's not blaming Zoom, he's not blaming Ms. Wanji, he's not blaming the court. But I would ask that his bond be reinstated as it was.
Well, and I had just increased the PR slightly until the hearing, but I was going to leave him on a PR bond. So, Ms. Buckner, the issue is, after I agreed to set a bond for you on the violation, I was checking whether you were following the conditions of your original bond. And everything went off the rails because normally when I say to someone, have you reported to pretrial services, I get one of two responses. Yes, I have, or I'll do it today. I didn't realize, or I had some issues. But your response instead was, I can't, my phone is broken. And I'm like, okay, but you could go there. And you started yelling at me with what right, which was disrespectful answer and not problem solving. Okay, so we do need your report to pretrial, or they're going to send me a non-compliance report that says you're not compliant with bond. But that's one of your conditions I need you to comply with. I also need you to stay in the state of Michigan unless you ask permission to travel. Don't commit crimes on bond. Seems pretty obvious. Show up for court dates. No alcohol, marijuana, illegal drugs, no firearms or dangerous weapons, no assaultive behavior. And then, as we already mentioned, that no contact with Ms. Reed. No contact means no contact whatsoever. No direct contact, no indirect contact. And there's this not to be within 2,000 feet of where she lives, works, or goes to school, except for, I guess, a pass through of the zone on your way to work. You have a question for Toby? Go ahead and ask him.
Not right now, but I can tell you this, if you have a new work location, with the pretrial services, no, I don't think she needs to write that in the file. You want that in your file on it?
I mean, it only matters if it affects the zone issue. The zone is surrounding her address, I believe the one on Linville Street. And so if this new work location keeps him away from the zone, that's great.
The one thing I would ask is this attorney, so I believe he may have to go through a prohibited zone driving to get to my office. I think at this point he has to go almost all the way to Hazlet and come around, as opposed to coming straight across Jolly Road. I don't know, but I don't want it to be an error. I haven't seen the map, so I don't know.
Okay, Mr. Buckner, remember the order of no contacts about you, it's not about her. If she's texting you or calling you, she might do that, she can do that. Maybe it's okay to get a text about how your child is doing. But if you text her back, you take that call, you're the one who could go to jail. She does not have authority to give you permission to violate the order. So if she invited you, meet up with her and you went, you'd still be the one who goes to jail. It looks like there's third-party contact for your 2 minor children allowed. So that means you can have contact with someone else about arranging to see your kids. No direct contact with her. And that third-party contact is literally only about your children. It's not about anything else. So be careful about that. Okay, as I tried to do yesterday, bond is set at $5,000, personal recognizance with all conditions in place. The hearing, the preliminary exam, and the bond hearing are in person on February 13 at 8:30 because evidence and testimony may be presented at that time.
I'd like clarification on the child, actually children in common. There is allowed to be
Third-party contact regarding.
third party. That's what I want to make sure.
Yep, third-party contact only, nothing direct,
Okay.
and nothing about any other topic
Okay. I know the mom and dad are involved.
with transporting or arranging.
I mean,
Timing,
yeah,
that's fine.
everything, communications, transporting, all that.
Okay.
Then I will direct him to borrow anybody's phone that he can and call
He
his
can
number.
go there. I walk there all the time. It's like 5 blocks from here. You can walk there.
Was it 30th? This is on the,
Yeah, it's on the first floor, right next to that food court.
yeah.
That is not a food court. I still think that's mislabeled. It's right next to the food court, it appears. And I know some people have done in-person reporting and just walk in there because it's easier than calling. Or you can call. Either way, whichever is easier for you. But, and Ms. Wanji was offering assistance yesterday to get him to use the phone, but if he could make it downtown, he could make it there in person. So it's like, all right, anything else?
I just want to point out, you've been shaking your head. Yes, she has been reciting all this. So I want you to verbally say on the record, I understand everything she said.
I really do understand everything you said.
All right, Mr. Buckner.
One. Yeah, I'll help you with that in a minute. It turns out that Ms. Reed is in Judge Simmons' court right now. So I want to be careful about him leaving the building and not having contact with her.
Okay.
She's down there with some misdemeanor pleas or something.
Well, I think he has to go back to 3 and be booked out. So he's going to be a minute and I have no idea what she's doing down the hall.
Yeah, I do, but it's just she's in front of her.
I'm just saying, I don't know how long she'll be in there.
Yeah, I know.
He should be out probably within a half hour.
Who's transporting? You said they were following you this morning. Okay, and you were in your vehicle?
I don't got a car. My car is.
Okay. You have a car at her house?
Yeah, I got 3 cars.
Okay, so we can do it through a third party. Can I make, Your Honor, for a third party, I'll make arrangements for him to get his vehicle, which is at the prohibited location.
Yeah, someone else can pick up his car. He just can't be the one to go over there.
I know. That's all then. Thank you.
Thank you.
So I'm gonna have you go with this gentleman.
All right. That is it. Yeah, it was kind of a slow ending, but yeah, his attitude brought him in brought him in the court in person in handcuffs. But hey, he owned up to him, so good on him. He didn't scoff at the court. He turned himself in, and he's being upfront with all of his questions, and maybe he is taking this serious. But I agree with Judge. As of yesterday, no, he wasn't. But yeah. It's a weird thing. You put those handcuffs on someone's wrist, they start thinking a little differently, huh? Okay. Hopefully you enjoy this, guys. If you did, please hit that like button. And until next time, bye.
Here, back down to 3. Okay. And I'll go scout out what's going on. And I will probably, how long will we, there's some chairs right down there in 3, right outside the jail. You sit in those chairs until I come and get you. So I can make sure she's cleared the area before you walk over to council. Thank you very much, Your Honor.
Thank you.